Imagine signing a lease, moving into your dream apartment, and then, bam! Your landlord hits you with an unexpected fee or tries to evict you for no clear reason. Sounds like a nightmare, right? If you're a tenant in the US, you might think you're at the mercy of your landlord, but here's the truth. You have more rights than you probably realize. In this video, we're diving into the legal rights of tenants in the US you didn't know about. Rights that can save you money, stress, and maybe even your home. Stick around, because by the end, you'll be armed with knowledge to stand your ground and rent with confidence. Let's get started. First off, let's talk about something called the implied warranty of habitability. This is a big one, and it's a right every tenant in the US has, no matter what state you're in. This legal principle says your landlord must keep your rental unit in a livable condition. We're talking basics here. Running water, heat in the winter, electricity, and a place free from things like mold, pests, or structural issues that make it unsafe. If your landlord isn't holding up their end of the bargain, you're not just stuck dealing with it. For example, let's say your heater breaks in the middle of a freezing Chicago winter, and your landlord drags their feet on fixing it. In most states, you can withhold rent until the repair is made, or even make the repair yourself and deduct the cost from your rent. Legally, just make sure you follow your state's specific process, like notifying the landlord in writing first. In California, for instance, tenants can deduct up to 1 month's rent for repairs if the landlord doesn't act within a reasonable time, usually 30 days. Check your state laws, because this right can be a game changer. Now, let's move on to something a little sneakier: security deposits. We've all been there, handing over a chunk of cash when we move in, hoping we'll see it again when we move out. But did you know there are strict rules about how landlords can handle your security deposit? In many states, like New York and Massachusetts, landlords are required to keep your deposit in a separate, interest-bearing account and provide you with the account details. They can't just toss it into their personal checking account and call it a day. Plus, when you move out, most states have a deadline for returning your deposit, often 14 to 30 days. If they don't meet that deadline or try to charge you for normal wear and tear, like faded paint or worn carpet, you can fight back. For example, in Texas, if a landlord doesn't return your deposit within 30 days and can't justify the deductions, you could sue for up to 3 times the withheld amount plus attorney fees. That's a serious incentive for landlords to play fair. Speaking of fairness, let's talk about your right to privacy. You might think your landlord can waltz into your apartment whenever they feel like it, but that's not true. Most states require landlords to give reasonable notice, usually 24 to 48 hours, before entering your rental unit, except in emergencies like a burst pipe. This right stems from your right to quiet enjoyment, a fancy legal term that basically means you get to live in peace without your landlord snooping around unannounced. In Florida, for instance, a landlord who repeatedly enters without proper notice could be violating your rights, and you might be able to break your lease without penalty. Picture this: Sarah, a tenant in Miami, kept finding her landlord poking around her apartment without warning, claiming he was checking the pipes. She documented every unannounced visit, sent a formal complaint citing Florida's 24-hour notice law, and when it didn't stop, she was able to legally walk away from her lease. Knowing this right can give you real power. Another right that often flies under the radar is protection against retaliatory eviction. Let's say you report your landlord to the health department for mold issues, or you organize a tenant union to push for better building maintenance. Your landlord can't just turn around and evict you or raise your rent out of spite. Federal law and most state laws protect you from retaliation for exercising your legal rights, like requesting repairs or reporting code violations. In Illinois, for example, if a landlord tries to evict you within 1 year of you making a complaint to a government agency, the law assumes it's retaliatory unless the landlord proves otherwise. This protection is huge because it means you can stand up for your rights without fear of losing your home. Just keep records of your complaints, like emails or certified letters, to back up your case if it comes to that. Now, let's touch on something especially relevant for renters in rent-controlled areas. Limits on rent increases. If you live in a place like New York City or San Francisco, where rent control or stabilization laws apply, your landlord can't just jack up your rent whenever they want. These laws cap how much your rent can increase each year, often tied to inflation or a fixed percentage. For example, in New York City, the Rent Guidelines Board sets annual increase limits for rent-stabilized apartments, which cover about 1 million units. In 2024, the approved increase was 2.75% for one-year leases. If your landlord tries to raise your rent beyond that, you can challenge it through your local rent control board. Even in non-rent controlled areas, some states require advance notice for rent hikes. 60 days in California, for instance, so you're not blindsided. One more right you might not know about is protection against discrimination. Under the Federal Fair Housing Act, landlords can't refuse to rent to you or treat you differently based on things like race, color, religion, sex, national origin, disability, or family status, like having kids. Some states go further, protecting against discrimination based on sexual orientation, gender identity, or even source of income, like using a housing voucher. For example, in Washington state, it's illegal for a landlord to refuse to rent to someone because they're paying with Section 8 assistance. If you suspect discrimination, you can file a complaint with the U.S. Department of Housing and Urban Development or your state's Fair Housing Agency. In 2023, HUD received over 30,000 fair housing complaints, showing this is a right worth knowing. Before we wrap up, let's talk about lease termination rights. Life happens. Maybe you lose your job or need to relocate. In most states, you're not always locked into your lease for the full term. For example, if you're a victim of domestic violence, many states, like Pennsylvania, let you break your lease early without penalty if you provide proof, like a protection order. Military members also have special protections under the Service Members Civil Relief Act, which lets you terminate a lease early if you're deployed or reassigned. Even without these specific circumstances, some states allow you to break a lease if the landlord breaches their duties, like failing to maintain a habitable space. Always check your lease and state laws, but these options can be a lifeline when you're stuck. So, there you have it. Legal rights every U.S. tenant should know about, from habitability to privacy, security deposits to protection against retaliation and discrimination. These rights are your shield against unfair treatment, but they only work if you know them and use them. Start by reading your lease carefully, researching your state's landlord-tenant laws, and keeping records of any issues.